The board demanded that I remove the swing from my backyard. I declined. The matter ended there, at least on paper. The person who issued that order also directed the community body responsible for approvals, hearings, and enforcement. Her signature touched every rule we lived under. A simple dispute over a wooden structure became something else. It became a question of who held power, why they believed they held it, and what happened when authority moved beyond its jurisdiction. It became an examination of process, assumption, and escalation. This story is less about a violation and more about the mechanisms that rise when no one challenges them. The incident was small, the consequences were not. Patricia Whitcomb waited for me the moment I stepped into the courthouse hallway, standing beneath the fluorescent lights as though they highlighted her authority. She spoke before I could sit down. "Your daughter cannot be in the hearing. Remove her or accept an additional fine." Her voice carried certainty, not confidence. She expected compliance. She always had. I answered quietly. The judge already approved her presence. Then, without raising my tone, I said the line that shifted the air between us. "Your board's authority is not what you think. I am Daniel Mercer, corporate compliance attorney, father, the only parent my daughter has left. The swing in our yard was built by my wife before she died. A final project she finished with the same care she gave everything in our home. The stain on the wood is still the one she chose. Our daughter still traces the grain with her fingers when she misses her mother. That swing is memory, stability, and history. It is also the reason we are here. The HOA claimed the swing violated a newly updated exterior guideline. They ignored the timestamp, the documentation, the permit number. They issued fines anyway, 50 at first, then 100, then the late notices, then the lien threat. The board did not escalate because of the swing. They escalated because they believed escalation always worked. That belief brought Patricia to the courthouse today, standing in a public hallway as if she were the one conducting the hearing. Inside the courtroom, the judge called our case. My daughter sat quietly beside me. Courtrooms are open to the public, and I had no childcare that morning. It was a procedural session, nothing more. Patricia objected to her presence again. The judge dismissed it again. Then, in a move that revealed more than any document could, Patricia reached for my daughter's arm as if she had the authority to remove her herself. I felt the deputies shift before I stood. They stepped between us with practiced efficiency, redirecting Patricia with emotion that required no words. The courtroom settled into a silence that felt heavier than outrage. The judge ordered a recess. Patricia stepped back, but only physically. Her posture held firm, a person who believed authority belonged to her because it always had. During the recess, I saw Eric Holloway, the HOA treasurer, slip into the rear bench. He did not sit with the board. He did not greet Patricia. He looked at the floor more than at me. People who carry something, they should not often look that way. When the judge reconvened, he requested additional filings and scheduled a continuation. No outcomes, no rulings, just time. Patricia did not understand the significance of additional time. I did. Outside, the winter air settled across the neighborhood. Notices began appearing again around Cedar Ridge Estates by evening. A planter violation, a mailbox warning, a stroller left on a porch. The pattern of targeted enforcement widened, as if the board were reminding everyone who held power. At my office that night, I reviewed the HOA's filings with the same detachment I used in regulatory audits. Something was missing, not a document, but a step. After the developer transferred control 6 years earlier, the board should have reestablished its corporate structure under state law. The records showed no such filing. Without it, the elections were invalid. The authority was invalid. The fines, liens, and enforcement actions were invalid. It was not a loophole. It was a structural failure. My daughter asked before bed if the swing would stay. I told her yes. I did not raise false hope. I answered with certainty because the law itself had made the answer simple. When my phone finally vibrated, it was Eric. His message said only 4 words. "We need to talk." I stared at the screen. The pattern was beginning to reveal itself. I met Eric the next morning at the community park, the same place where families gathered on weekends and where HOA notices were often posted without warning. The grass was damp from the night air, and early sunlight stretched long shadows across the playground. Eric sat alone at a bench near the notice board, his shoulders tight, his hands clasped together like he was bracing for something heavy. I approached quietly, giving him space to speak first. He didn't look up. "I saw what happened yesterday," he said. His voice barely carried over the wind. "She shouldn't have touched your daughter. None of this should have gone that far." He paused before adding, "I'm sorry." Apologies from an HOA board member were rare. Sincere ones were almost non-existent. I took the seat across from him and waited. He kept his gaze trained on the playground, as if the slide and swings could shield him from his own involvement. "She thinks she's untouchable," he continued. "Patricia, she thinks the board can do whatever it wants because nobody ever pushes back. People are scared of her, or tired, or both." His hands tightened. "But I can't keep covering for them." I asked him what he meant, though I already understood more than he realized. His posture, the look in his eyes, the quiet resignation, these were the signs of someone who had watched bad decisions accumulate over years and finally reached a line they couldn't cross. He didn't answer right away. Instead, he lifted a stack of printed notices sitting beside him on the bench. Violations. New ones. Posted overnight. He handed me one. A young couple fined for a bicycle left near their porch. A retiree cited for weeds along her walkway. A single mother warned about a garden fence that had stood for 12 years. It was a sweep, not targeted, widespread. A message disguised as enforcement. "It started last night," he said. "The board thinks pressure will force you to remove the swing before the hearing. They want to show strength." He exhaled slowly. "They don't understand what they're stepping into." I did. A governing body cannot aggressively enforce regulations it has no legal standing to enforce. Each action they took now only strengthened my position. Each overreach built the record. Each fine pushed them further into territory they didn't legally control. They believed escalation proved authority. In reality, it exposed the absence of it. I asked Eric why he joined the board in the first place. He shrugged. "I wanted to help. I thought I could make things better. But once Patricia took over, everything became about control, not management, not community. Control." He finally looked at me. "We never refiled the transition documents when the developer handed things off. She knew. We all knew. She said we'd fix it later. We never fixed it." His voice lowered to a whisper. "She ordered us not to talk about it." Silence settled between us. Birds moved across the sky. A child ran across the grass chasing a ball. Normal life continued while a quiet structural failure sat beneath the entire neighborhood like a crack in a foundation. Invisible until pressure found it. I asked him why he was speaking now. He swallowed hard. "Because yesterday showed me how far she's willing to go. If she'll grab a child in a courtroom, what won't she do?" He shook his head. "This isn't enforcement anymore. It's something else." A breeze lifted the edges of the violation notices posted on the board behind him. Each page fluttered as if trying to pull free. I stood and walked toward them. 15 new fines, 3 warnings, 1 threat of immediate lien. This was not management. It was intimidation made procedural. A woman walking her dog slowed as she noticed the board. She read the notices, frowned, then glanced at me. We had never spoken before, but her expression said enough. People were aware now. Awareness changed things. Awareness created witnesses. In neighborhoods governed by associations, silence is often compliance. Awareness breaks silence. I returned to the bench. Eric's hands were shaking. I set my palm on the stack of papers he'd brought. "These notices," I said, "do more for my case than anything else." He nodded, still looking at the playground. "I'm scared of her," he admitted. "But I'm more scared of what happens if this keeps going." His fear wasn't weakness, it was clarity. People who understand systems often fear them before anyone else realizes something is wrong. We sat in the quiet for several minutes. The park filled slowly with families starting their morning routines. Life continued, unaware that its structure was beginning to shift. I stood to leave. "The hearing is next week," I told him. "Everything you've said matters, but only if you're willing to confirm it when the time comes." He didn't answer immediately. Then he nodded. "I will." As I walked away, the notices behind us rustled again. Not warnings, not rules, evidence, all of it building towards something the board could no longer stop. This was no longer about a swing. It was about authority finally meeting its limit. Eric's agreement stayed with me long after I left the park. By the time I reached the HOA administrative office later that afternoon, I could still see the look on his face. Not defiance, not courage. A kind of quiet devastation. The expression of someone who finally admitted what he had known for years but never allowed himself to face. That was the part that worried me. People who struggle internally often waver when pressure arrives, and Patricia applied pressure like a profession. The HOA office sat at the edge of Cedar Ridge Estates, a glass-fronted suite inside a small strip complex that once housed a dentist and a tutoring center. Now it held the machinery of the association, filing cabinets, meeting tables, and a staff trained to treat homeowners like clients instead of residents. I stepped inside. The front desk receptionist looked up, hesitated, then offered a tight smile that didn't reach her eyes. She knew why I was here. I requested copies of the newest violation notices and the supplemental documentation the board claimed justified the fines. She disappeared into the back room, leaving me alone with the sterile scent of printer toner and the low hum of fluorescent lights. Through the office window, I could see residents passing by on the sidewalk outside. Some glanced in. Most kept their heads down. Nobody liked being seen inside the HOA office. It suggested trouble. A door opened down the hall. Eric stepped out, papers clutched in his hands. He froze when he saw me. His body tensed first. His shoulders rose slightly, then dropped as if he forced them to. His eyes darted toward the closed boardroom door behind him, lingered, and returned to me. He walked over slowly, like each step required permission. "You shouldn't be here when she's around," he murmured. His hands told the truth more than his voice. His fingers pressed deep creases into the papers he held. His left thumb kept rubbing a small circle against the corner of one sheet, like he needed the movement to stay steady. His breathing was shallow, almost imperceptible. Fear had a shape, and he carried all of it in his posture. "I'm here for the notices," I said. He nodded once. The motion was mechanical, not voluntary. He extended the documents toward me, but his grip lingered longer than necessary before he let go. His eyes flicked again toward the boardroom door. Something inside that room was pulling at him. Loyalty, guilt, obligation, maybe all three. "She's pushing for an emergency board session," he said quietly. "She wants to accelerate the enforcement process. She thinks you're planning something." I didn't answer. The less he knew about my strategy, the safer he would be. His internal struggle was already tearing at him. If I added pressure, he might break. "She said the community must see consequences," he continued. "She thinks the crackdown will make people fall in line." His voice wavered. His knees shifted. He lifted a hand to adjust his glasses, but the gesture was misplaced. His glasses were already straight. It was a nervous tick, one he didn't notice. "She doesn't know what she's doing, Daniel," he whispered. "She thinks authority is the same as power." He swallowed. His Adam's apple rose and fell sharply. I asked him a simple question. "Did the board vote on the escalation?" He didn't answer with words. His face did it for him. His jaw tightened, his gaze lowered, and he folded his arms across his chest. Not defensively, but as if holding himself together. The board hadn't voted. Patricia was acting unilaterally, and he knew it. Before he could speak again, the boardroom door opened. Patricia stepped out, her expression composed and hostile in equal measure. Eric stiffened instantly. His shoulders locked, his spine straightened. His hands vanished behind his back like a schoolchild caught talking to someone he shouldn't. "Mr. Mercer," she said, not bothering with a greeting. "This office is not a discovery center. If you need documents, submit a written request." Her attention shifted to Eric, and I saw him shrink, not physically, but inwardly. His feet angled slightly away from her, as if ready to flee but unwilling to take the step. His fingers curled against his palms. Even his breathing paused. She dismissed him with a glance. "Treasurer Holloway, we have work to finish." Eric didn't move. For a long second, he stood frozen between us, the conflict inside him pulling in the opposite directions. His loyalty to the board on one side, his conscience and fear on the other. His foot tapped once, twice, tiny tremors of panic. Finally, he nodded and followed her back inside. The door closed behind them with a soft but final click. I stepped out of the office, the documents in hand. Each new violation, each unilateral action, each procedural shortcut only tightened the noose around the authority Patricia believed she wielded. She thought she was building a case against me. She was building a record for the judge. And Eric, torn between truth and obedience, was approaching a breaking point, the kind that created witnesses. This was the part of the process where overreach always revealed itself. The board was accelerating. And acceleration, in governance, always exposed the cracks first. I left the HOA office knowing what would come next. Overreaching boards follow a pattern. They escalate faster when they feel control slipping, and they escalate blindly when they believe no one can stop them. Patricia had already crossed that threshold. The next move would be unmistakable. By evening, it arrived. A courier envelope was waiting on my porch when I returned from work, tucked neatly against the welcome mat as if it were a casual delivery. My daughter was inside drawing at the kitchen table, humming to herself, unaware of the heavy shift unfolding around us. I picked up the envelope, noting the emblem stamped in the corner. Cedar Ridge Estates Association, urgent, enclosed documents, my name printed in block letters. The envelope was thicker than a normal notice. That mattered. Boards only send this version when they intend to make a statement. Inside were 3 documents: a formal notice of accumulated fines totaling nearly $3,000, an immediate lien intent declaration, and a summons for a special enforcement hearing scheduled within 72 hours, not the regular hearing, not the scheduled continuation in county court, a separate internal tribunal the board used when they wanted to intimidate homeowners without legal oversight. This was the escalation. The association had no standing to issue fines. They had no standing to threaten liens. They had no standing to schedule hearings. But the more they acted like an authority, the more evidence they created showing they believed they could exercise power they did not legally possess. Every misstep tightened the vice. Still, the summons meant one thing clearly. Patricia was accelerating her attack, and she was doing it fast. I set the papers on the kitchen counter and took a breath. My daughter continued humming softly, flipping a page in her sketchbook. I watched her for a moment, the rhythm of her pencil tapping the paper, the ease with which she existed despite the conflict swirling around us. The swing in the backyard gently creaked in the evening breeze, as if it too remembered why this fight mattered. I moved to my workspace. My legal background gave me tools most homeowners never had. The documents had to be examined, cataloged, and preserved, not for their content, but for their defects. Every improperly issued fine became evidence. Every scheduled meeting without jurisdiction became a procedural violation. Every threat became a record of abuse. The first document contained a line I had expected. Failure to comply will result in immediate escalation of enforcement remedies, a phrase used often in HOA communications. Except here, the corporation behind the letter lacked the legal structure required to enforce anything. The statutory requirement for a post-developer transition filing was absent. The last legitimate registration was 6 years old. That gap was fatal, and they had just widened it. I recorded the timestamp, scanned the envelope, and filed everything into my case archive. The escalation was important, not because it changed my position, but because it exposed theirs. The second document, the lien notice, was even more damning. A lien can only be recorded by an association with proper corporate authority. Filing one without standing creates liability. Attempting to file one creates a paper trail that can be used to demonstrate misconduct. This was not just overreach, it was negligence. The third document, the special enforcement hearing summons, contained a location: the community clubhouse. I had not been inside since the board barred me from entry. It was a space that once held neighborhood gatherings, birthdays, town halls. Now it held only tension and procedural aggression. I circled the date and time: 72 hours, a predictable move, rapid escalation to trap me into a defensive reaction. But I had no intention of reacting, only observing. As I reviewed the documents, my phone buzzed. A single message from Eric. "Did you get the packet?" The wording was short, but the meaning was heavy. He was involved in its assembly, or forced to be. His internal conflict was growing sharper, more visible at every step. He was trapped between the board's pressure and the truth he could no longer ignore. I replied simply, "I did." 3 dots appeared, disappeared, then appeared again. He was typing, deleting, typing again. His hesitation said more than his words. Finally, a message came through. "I didn't vote for it." I typed back, "I know." He read it. No reply followed. The special hearing would be the board's attempt to cement its authority. They believed a show of force would push me into compliance. What they didn't realize was that every attempt to assert power was another step outside their jurisdiction, and every step outside their jurisdiction was another point in my case. I walked to the backyard and looked at the swing. The wooden frame stood firm, the ropes gently swaying in the wind. It had survived storms without moving an inch. So had we. The board was accelerating fast. But acceleration only works when the structure beneath you is stable. Theirs was not. The next morning, I drove straight to the county clerk's office. The building sat beside the old courthouse, a beige structure with narrow windows and a steady stream of residents moving through it for permits, filings, and records requests. It was a public space, neutral ground, and unlike the HOA office, nobody held manufactured authority here. Everything was documented. Everything was verifiable, and for what I needed, verifiable was enough. Inside, clerks worked behind tall counters arranged in long rows. Shelves lined the walls, filled with binders organized by year and jurisdiction. The air smelled faintly of paper dust and toner. I approached the records desk, requested the association's historical filings, and provided the docket numbers from the developer's original incorporation. The clerk nodded, typed a few entries, and began printing. As pages slid out of the machine, I could already see what was missing. Not a document, but a sequence, a mandatory sequence. The Cedar Ridge Estates HOA had filed regularly for its first 4 years under the developer's management. Transfers were documented, annual statements were logged, board transitions were properly recorded. Then, after the official handoff 6 years ago, the filings simply stopped. No annual update, no renewal, no corporate conversion, nothing. The board existed only in practice, not in law. The clerk stacked the pages neatly and stamped the top sheet with the county seal. I thanked her and took the packet to a nearby table. Sunlight streamed through the narrow windows, cutting clean lines across the surface. I laid out the filings, comparing dates, cross-referencing statutes, checking every detail twice. The pattern was clear. The association had ceased being a legally recognized entity when the developer stepped away. Everything after that point, the elections, the bylaws, revisions, the enforcement actions, were conducted without the authority required by state law. This was more than an error. It was a structural void. And the documents in that packet, signed by county staff and logged in public record, were the foundation of the standing challenge I had been building quietly since the day the first violation notice arrived. My phone buzzed. A message from an unfamiliar number. I heard they sent out lien notices again. People are upset. Another buzz. Is it true you're taking them to court? Word traveled fast in neighborhoods governed by fear, and fear had been Patricia's most reliable instrument. But fear works only when people believe the authority behind it is legitimate. I gathered the documents and stepped outside. The air was warmer than earlier, the sun higher. The courthouse bell rang in the distance. People moved with purpose along the sidewalk. Attorneys in suits, contractors filing permits, families renewing documents. Real processes, real oversight, real governance. Everything the HOA claimed to have, but no longer possessed. The county clerk's office was a place where authority came from statute, not assumption. And today, that difference mattered. I walked toward the courthouse steps and paused. From here, I could see Cedar Ridge Estates in my mind, the manicured lawns, the uniform mailboxes, the sterile board notices posted in perfect alignment. A community run by a structure that believed itself untouchable. A structure that had forgotten what made authority real. Standing challenges are simple in concept, but devastating in execution. If an entity lacks legal standing, any action it takes is void. And the more actions it takes without standing, the deeper the liability becomes. The HOA had taken dozens, maybe hundreds. I sat on the courthouse steps and reviewed the filings again. The absence of renewal, the missing post-transition declaration, the failure to register the board's authority after the developer withdrawal. Each omission was documented, time-stamped, and archived with official signatures. Each one was evidence of a governance structure that had continued to operate despite losing its foundation. I could hear my wife's voice in moments like this. She used to say that rules mattered most to the people who followed them, not the people who wrote them. The swing she built was never the real issue. The issue was the assumption that they could rewrite its meaning by rewriting their own rules. A small group of residents approached the courthouse steps. 2 of them recognized me. Their expressions carried something new. Not accusation, not fear, curiosity, hope even. They hesitated before walking past, but I could see the shift. People were starting to notice the cracks. I stood, collected the documents, and returned to my car. The special hearing was now 72 minus 8 hours away. The board believed it would be their stage to demonstrate control, but control without jurisdiction was only theater. Before driving off, I sent a single message to Eric. I have what I need. No details, no strategy, just the truth. He replied within seconds. Then we're closer than she realizes. I placed the filings on the passenger seat and started the engine. What began as a backyard swing dispute was now a matter of legal existence, and only one side had the law under its feet. When I pulled into the driveway, the afternoon sun had already begun sinking behind the rooftops, casting the neighborhood in long, slanted shadows. The swing in the backyard moved gently, as if the wind itself was remembering the hands that built it. I carried the county filings inside and placed them on my desk, each page a quiet reminder that the foundation of the HOA's authority was already crumbling. The next step wasn't to confront them, it was to prepare with precision and patience. I opened my laptop and reviewed the hearing notice again. 48 hours remained until the special enforcement session at the community clubhouse. It was designed to intimidate, not negotiate. But intimidation only works when the target lacks clarity. I had clarity now. The standing defect wasn't just a small oversight. It severed the association from any legal ability to enforce its own rules, issue fines, or record liens. The clubhouse had once been a place for gatherings and celebrations. Today, it represented something very different, a facade of authority. The board would attempt to stage their power there, but the structure behind their actions had already collapsed. My role was simply to document the fall. Before leaving, I checked on my daughter. She sat on the living room floor surrounded by crayons, drawing a picture of the swing. A simple sketch, 2 posts, a wooden seat, a sun overhead. Her expression was peaceful, unaware of the forces moving against us. I brushed a hand over her hair and told her I'd be gone for an hour. She nodded without looking up, focused on the world she was creating line by line. I drove to the clubhouse. The parking lot was half full, unusual for a weekday. Inside, a few residents were setting up folding chairs for an evening yoga class. The smell of lemon cleaner filled the room, sharp and sterile. The walls were lined with framed photographs of community events, barbecues, holiday gatherings, summer festivals. The board had been the center of all of it once. Now, those images looked like a record of a version of Cedar Ridge that no longer existed. I walked to the back corner, where a small corkboard displayed announcements and internal memos. A fresh sheet of paper had been pinned there. Emergency board session, closed to homeowners. No date, no signature, no procedural notice. Just an assertion of authority typed in bold letters. I studied the boardroom door, closed and silent. Behind it, the board was likely preparing their strategy. One built on the assumption that their power remained intact. They believed tomorrow's special hearing would be decisive. They believed they could intimidate their way to compliance. They believed above all that their actions still had legal force. Belief, however, is not jurisdiction. The door opened suddenly. A woman stepped out. One of the board members, Melissa Price. She froze when she saw me. Her posture stiffened, her mouth tightened, but she didn't speak. Her eyes flicked to the papers in my hand, then to the exit, as though calculating whether acknowledging me would be seen as disloyal. "Evening," I said. She nodded curtly, then stepped away quickly, disappearing into the hallway. That reaction told me more than her words could have. The board wasn't unified. Not anymore. Fear had begun to replace confidence. I approached the window and looked out at the neighborhood. From here, I could see rooftops stretching into the distance, each home bound to a system that had assumed its own permanence. Systems like these rarely expect inspection. They depend on compliance, not scrutiny. When scrutiny arrives, cracks spread. I took a seat at one of the round tables near the back. The yoga class began setting up mats. I opened my laptop and began drafting the initial framework for the standing challenge. Not the argument itself, that would come later, but the skeleton. Points of defect, gaps in filing history, violations of state statute, misuse of authority, evidence of harm. Every sentence had to be precise. Every reference had to be anchored in verifiable record. If the board attempted a procedural ambush tomorrow, I needed to be ready with documentation that didn't rely on interpretation, only fact. Half an hour passed. Residents trickled in for class. Conversations shifted across the room. Small talk, weekend plans, quiet frustrations about fines. The atmosphere carried an undertone of fear, but also curiosity. People sensed something growing beneath the surface, something shifting in their favor without fully knowing why. I closed my laptop and stood. As I walked toward the exit, a hand brushed my sleeve. I turned. An older man, someone I recognized vaguely from community meetings, leaned in slightly. "Whatever you're doing," he whispered, "don't stop." He didn't wait for a response. He joined the yoga group and unrolled his mat. Outside, the sky had turned a deep amber. I breathed in the evening air and felt a clarity settle in my chest. I wasn't preparing for a fight. I was preparing for a correction, a restoration of order where authority had drifted beyond its mandate. The board wanted confrontation. What they would receive instead was consequence. The next 48 hours would determine everything. The next morning arrived with a kind of stillness that felt deliberate, like the neighborhood was holding its breath. I stepped onto my porch, coffee in hand, and watched the quiet street. Cedar Ridge had always looked peaceful from the outside. The conflict, the pressure, the intimidation, those lived behind windows and HOA letters. But today there was something else lingering in the air. A shift. A waiting. My phone buzzed. A single message from Eric. "Can we talk? Not at the office?" I replied. "Where?" He suggested a place I hadn't visited in years, the old community walking trail behind the retention pond, a location rarely used since the board built the new recreation area. It was quiet, secluded, and out of sight of HOA offices and passing residents, a neutral space where he wouldn't be watched. I left my daughter with a neighbor she trusted and drove toward the trailhead. The gravel path wrapped behind the pond, sheltered by trees whose branches arched overhead like an abandoned canopy. Birds moved in the brush. The water was still. A light breeze carried the smell of damp earth. Eric was already there, pacing near the edge of the path. His movements were restless, controlled only in form, not in purpose. When he saw me, he stopped mid-step and exhaled like someone finally allowing himself a moment to breathe. "Thanks for meeting," he said. His voice was tight, the sound of someone holding in more than he could carry. "What happened?" I asked. He rubbed his forehead, fingers trembling. "Last night's board meeting, she pushed it too far." His eyes flicked to the ground, to the pond, to the trees, anywhere except directly at me. "They want to go after your mortgage next. They think threatening your lender will force you to comply." That was exactly what I expected, but hearing it confirmed something deeper. Patricia wasn't just escalating, she was panicking. And panic in governance is the clearest sign that the decision-makers know the structure beneath them is unstable. Eric continued pacing, talking faster than before. "They drafted a resolution to declare you a nuisance homeowner. It's illegal, Daniel, completely illegal. But she said it proves authority." The board members just nodded. They always nod. His hands flexed open and closed like he was trying to rid himself of something sticking to his skin. "Eric," I said, "why are you really here?" He stopped again. The question landed harder than I intended. His shoulders slumped. "Because I can't keep pretending I don't know what's happening." His voice cracked, not loudly, but enough that he caught himself, swallowed, and looked away. I joined the board to help this community, but this isn't community anymore. It's punishment. He pulled a folded sheet of paper from his jacket. His fingers shook so violently he had to steady them against his leg before handing it over. The sheet contained internal board messages, emails between Patricia and the other officers, plans for accelerated enforcement, notes about residents needing discipline, and at the bottom, a time-stamped exchange, a directive from Patricia to skip a procedural vote and push through the action regardless of compliance. A smoking gun. She told us not to put it in writing, Eric said, but some members replied anyway. She doesn't realize how these records work. He paced again, steps uneven, his breath visible in the cool morning air. His eyes darted to the pond, then the path, then back to the paper in my hand, like he feared he'd already gone too far. I know these messages matter, he whispered. I know the filings you showed me matter. I know the board isn't legitimate anymore, and I know the judge will see it. But when this goes public... He stopped walking. His chest rose sharply. I don't know who I am in all of this. That was his real confession. Not fear of Patricia, fear of himself, of what stepping forward would reveal about the choices he made by staying silent for years. You'll be the one who told the truth, I said. He shook his head slowly. Not soon enough? The wind moved through the trees above us, shaking loose a few leaves that drifted to the ground between us. The pond rippled slightly, disturbed by something unseen beneath the surface. Eric took a steadying breath. I'll testify if the judge asks, and I'll confirm the filings weren't updated, but... He hesitated. I can't stand with you publicly. Not yet. I'm not ready for that fallout. I'm not asking you to, I replied. His shoulders eased a little, as if he didn't believe he deserved leniency, but needed it anyway. What you're giving me is enough, I added. He nodded, but the gesture was fragile. His hands slipped into his pockets to hide the trembling. His gaze lowered again, tracing shapes in the gravel. The conflict inside him was still there, heavy, unresolved, but now angled toward truth rather than silence. We're running out of time, he said. Tomorrow's hearing is going to be ugly. He wasn't wrong. A board built on broken authority doesn't collapse quietly. As we walked back toward the trailhead, Eric said one last thing, barely above a whisper. She thinks she's about to win. I folded the emails into my jacket. She already lost. The path behind us rustled with wind, the sound of something shifting. The standing challenge was no longer theory. It was beginning to unfold. I drove straight from the trail to the Regional Law Library downtown, a quiet brick building tucked between the courthouse annex and an old municipal archive. It wasn't a place most homeowners ever stepped into, but for me, it had always been familiar territory. Rows of statute books, case reporters, municipal codes, and regulatory guides lined the shelves. Everything here operated on precision, not assumption, and precision was exactly what the next phase required. Inside, the air was cool, the lights soft, and the silence thick enough to settle on your shoulders. Law libraries have a certain gravity. They remind you that systems are built, not imagined. Authority is granted, not claimed. I found an empty table near the back and spread out the documents, county filings, HOA notices, internal emails, and statutory printouts. Each page represented a different thread. My job now was to weave them into a single, unbreakable structure. The standing defect wasn't enough on its own. It had to be framed correctly, presented in the right order, supported by the right statutes. A standing challenge is like a lockpick. It only works when inserted at the exact angle. I started with the statutory foundation, Texas Property Code, corporate transition requirements, developer to board handoff procedures. Each section needed to align with the missing filings, showing not just absence, but violation. The board had operated for 6 years without the authority required by law, and each enforcement action since the lapse was void. As I built the outline, I could feel the shape of the argument sharpen. Not emotional, not personal, procedural, detached. The kind of argument judges respect because it does not rely on interpretation, only fact. My laptop chimed with a notification, a message from an unknown number. They're preparing something for tomorrow. Heard it will be public. Another message followed. Be careful. Fear was moving through the neighborhood faster now. Residents were whispering, watching, waiting. Pressure reveals more than truth. It reveals character. And Patricia was reacting exactly the way leaders react when they realize their authority is performative. I kept working. The next step was assembling the timeline, the lapse in filings, the years of invalid elections, the enforcement actions issued without jurisdiction, the recent surge of fines and threats, the attempted lien, the unauthorized hearing, and finally, the assault in the courtroom, a moment that had publicly shown the board's belief that control justified any action. I laid the documents side by side. The pattern looked almost mathematical in its clarity. Authority claimed, authority unverified, authority misused, authority collapsing. As I worked, a librarian walked past, glanced at the spread of papers, paused, and nodded with a quiet kind of understanding. People who work in places like this recognize structural failure when they see it laid bare. My phone buzzed again. This time, Eric. I can't stop shaking, his message said. She's pushing everyone hard. They don't know what I told you. I typed back, you're doing the right thing. 3 dots appeared, then disappeared, then returned. Finally, he sent, she moved the meeting time, earlier than planned. She wants to corner you. I closed my eyes for a moment, absorbing that. Of course she moved it. When systems feel pressure, they accelerate. When authority fears exposure, it rushes. And rushing almost always leads to mistakes. I returned to the work. Next came building the formal structure of the motion. It didn't need theatrical language. It needed clarity. A judge doesn't want drama, they want sequence. So I drafted the skeleton. Identification of the statutory requirement for post-developer transition. Presentation of the public filings showing the lapse. Explanation of the legal consequence. Dissolution of standing. Evidence of improper enforcement actions taken without authority. The unavoidable conclusion, the HOA could not legally issue fines, threaten liens, or hold hearings. Every point could be verified with certified records or internal board communications. No speculation, no conjecture. Just facts aligning with each other like machined parts. I took a break, walked to the tall windows, and looked out at the courthouse across the street. People moved quietly below, carrying briefcases, documents, coffee cups. Real systems, functioning systems, governed the world out there. The HOA had forgotten it belonged to that world, not above it. When I returned to the table, I added the final necessary piece, the request for judicial review of the association's authority. That was the key, not an accusation, not an attack, a request for verification. Verification is the enemy of false authority. By late afternoon, the outline was ready, clean, precise, unshakable. I gathered everything, placed the filings carefully into labeled folders, and closed the laptop. As I slid the documents into my bag, I felt a certainty settle into place. Not confidence, not hope, certainty. The kind that comes when the law and the facts sit squarely on your side. Tomorrow's hearing was supposed to intimidate me. Instead, it would be the moment the board's authority finally met scrutiny. As I left the library, the sun dipped low, casting long shadows across the courthouse steps. The next phase wasn't about argument. It was about exposure. I left the law library with the folders secured in my bag and drove to a place that had never been part of this conflict, but would now shape the final stage of it, the downtown co-working center. It was a glass-walled, open-floor workspace built for freelancers and small teams, far removed from Cedar Ridge Estates. Neutral ground again. No HOA presence, no suspicious eyes. Just quiet tables, private booths, and the low hum of people focused on their own projects. I chose a corner booth overlooking the street below. Cars streamed past. Office workers crossed at the light. The world moved normally out here, untouched by the petty power games of neighborhood politics. It reminded me that what I was preparing wasn't dramatic. It was procedural, methodical. The natural correction of a structure that had drifted from the law. I placed the folders on the table and opened them. The filings, the timelines, the emails, the statutory excerpts, they formed a framework now. What remained was positioning, evidence organization, statement drafts, supporting documents. Everything needed to be compiled cleanly so the judge could follow it without interruption. I began ordering the documents into sections, each with its own header, each one told a part of the story, not the emotional story, but the administrative one. That was the version that mattered in court. Filing lapse, evidence illegitimate board, elections, improper enforcement notices, threat of lien without authority, internal directives demonstrating knowledge, recent escalation, pattern, harm to homeowner. Due to invalid authority. The structure formed itself as I worked piece by piece until the argument was no longer abstract but tangible, printed on paper, labeled, time-stamped, ready for judicial eyes. As I organized the pages, my phone buzzed again. This time it was a resident I barely knew, someone who had once asked the board permission to install a ramp for his elderly mother. The board denied him. He had built it anyway, and they fined him repeatedly. His message read, "We heard the board moved the hearing earlier. People think they're trying to corner you." Another message followed. "If you need signatures or statements, we can help." I didn't respond. Not yet. Their support mattered, but too much involvement too early could jeopardize the procedural clarity I needed. What mattered now was focus, preparation, accuracy. I returned to the work. The next phase was creating the evidence binder, a tool judges appreciate more than dramatic speeches. I inserted each document into plastic sleeves, building the binder section by section. The weight of it increased steadily as the pages filled. With every click of the rings, I felt the structure of tomorrow's confrontation move from idea to inevitability. I added the photographs, the swing, the violation notices, the time stamps. Visual evidence often provided context in ways text alone could not. As I worked, the co-working center filled gradually. Young developers, marketing teams, remote workers, all absorbed in their tasks. Their quiet persistence helped anchor my own. The hum of printers, the clicking of keyboards, chairs shifting, coffee being poured, life in motion, purposeful and procedural. When the binder was complete, I moved to preparing the witness materials. Eric's notes were fragile, emotionally and legally, but necessary. His internal emails were critical pieces of corroboration. I arranged them in order, highlighting only the relevant sections, not names, not personal details, only procedural references. Judges care about systems, not drama. Next, I drafted a summary page, a single sheet that distilled the entire argument into one paragraph. If the judge needed the essence, it had to be available at a glance. One line mattered more than the others. The association has acted continuously for 6 years without statutory standing. The truth in that sentence carried more force than any confrontation the board could stage tomorrow. As I finished the summary, my phone vibrated again. This time, it was a voicemail from Eric. I didn't need to listen to know the tone. Fear, conflict, pressure. He was caught between truth and the consequences of revealing it. His internal struggle had carved deeper lines into his posture each time I saw him. Still, he had taken the step that mattered. He had decided which side of the process he stood on. I sat back for a moment, closing the binder gently. The evening light outside the window had shifted to a golden hue, casting patterns across the workspace. For the first time all day, I allowed myself a moment of stillness. Tomorrow wouldn't be the end. The board's actions were too extensive for that. But tomorrow would be the beginning of the correction, the moment the judge recognized the absence of standing, the moment the structure cracked under its own weight. I gathered the binder, the folders, and the electronic copies on my laptop. Everything was ready. As I walked out of the co-working center, the sky above the city darkened, streetlights flickering on one by one. The neighborhood would be preparing for its own version of tomorrow, a show of force, a staged demonstration of authority. But authority without legality is only noise, and tomorrow the judge would hear more than noise. He would see the truth. I left the co-working center with the binder secured under my arm and drove to a place I had not used for anything serious in years. A small, quiet diner on the edge of town. It sat beside an old service station, far outside Cedar Ridge, with a neon sign that flickered in and out like it had given up trying to stay lit. The diner was usually empty between dinner and midnight, which was exactly what I needed. Neutral ground, no residents, no board members, no tension leaking through the walls. Inside, the booths were lined with cracked red vinyl, and the overhead lights buzzed faintly. A waitress gave me a nod of recognition, the kind you give someone who comes in often enough to remember, but not enough to know well. I took a booth near the back, away from the windows, where I could spread out the binder and prepare without interruption. The special hearing at the clubhouse was less than 20 hours away. The board expected intimidation. They expected performance. What they wouldn't expect was structure, and tomorrow, structure was the only thing that mattered. I opened the binder and reviewed each section again. Filing lapses, statutory citations, emails showing knowledge of defect, timelines proving invalid elections, enforcement notices issued without authority, harm documented. Everything aligned cleanly, every piece of the argument supported by official records. The waitress brought a cup of coffee without being asked. "You look like you're preparing for something big," she said gently. "I am," I replied. She smiled faintly and moved on, leaving me alone in the quiet hum of the diner. The sounds of the kitchen, clattering pans, running water, blended into background noise, giving me space to think. My daughter's drawing sat beside the binder. I had tucked it into my folder earlier without thinking. Her simple picture of the swing, drawn with the certainty only a child can hold. It reminded me of why I was sitting here instead of home, why the process mattered so much, why I couldn't afford to falter. The swing wasn't a violation. It was a memory, a promise, a place where my daughter still felt her mother's presence. And for 6 months, the HOA had tried to erase it with the stroke of a pen. Not tomorrow. I closed my eyes and mentally walked through the next day. The clubhouse, the board lined up behind their folding table. Patricia seated in the center, wearing authority like armor. Residents watching from the back, uncertain but alert. Eric somewhere between them, shoulders tight, gaze lowered, carrying a truth he could no longer hide. Then the moment they asked for my compliance, and the moment I asked for their standing. Not theatrics, not defiance, just one procedural question. And everything afterward would fall under the weight of the answer. I flipped through the binder once more, checking for gaps. None remained. The argument was complete, supported, clean. It wasn't an attack on the board. It was a verification request. Judges do not fear verification. Boards built on invalid foundations do. My phone buzzed again. A message from a number I recognized this time, a neighbor who rarely spoke during gatherings. "We heard the board is planning to make an example of you. People are scared." Another message followed seconds later. "But we're paying attention, finally." Awareness spreads quietly, and once it begins, it rarely goes backward. I set the phone aside and continued reviewing the final section of the binder, the request for judicial review. The language was simple, respectful, procedural. The strength lay not in tone, but in documentation, the one thing the board had failed to maintain. A gust of wind rattled the diner windows. A distant train horn echoed from the tracks across town. The stillness inside made the outside world feel even more distant, as though the diner existed between one moment and the next. The door opened. A man walked in wearing a Cedar Ridge windbreaker. He scanned the room, eyes landing on me briefly before he took a seat at the far end. Not a board member, just a resident. Even here, the conflict followed in whispers and glances. I gathered the papers into the binder and closed it gently. Everything was ready. There would be no surprises tomorrow, not for me. The only surprises would come for the board. As I sipped the last of the cooling coffee, I thought of the swing again, the way it had survived storms without ever losing its place. So had we. I slipped the binder back into my bag and stood. The diner's neon sign flickered again as I stepped outside into the night, the cold air sharp and clear. Tomorrow wasn't a confrontation. It was alignment. A moment when authority would meet the law it had ignored. The board had spent months building a stage. Tomorrow they would step onto it, under scrutiny, under record, under consequence. I headed toward the car. The night was silent. The correction had already begun. The morning of the special hearing broke cold and bright, the kind of light that makes everything look sharper than it should. I arrived at the community clubhouse 10 minutes early, binder in hand, and found something I had not expected. A crowd. Dozens of residents stood gathered outside the entrance. forming a loose semicircle around the glass doors. Some clutched violation notices. Others held their arms folded tightly, watching the building as if it were a courthouse about to deliver a sentence of its own. Word had spread faster than any board announcement. When I stepped onto the walkway, conversations shifted. People turned. A few nodded. A few stepped aside. The energy wasn't supportive or hostile. It was anticipatory, like everyone had come expecting a spectacle, but not sure which direction it would fall. Inside the clubhouse, the board had arranged the room like a tribunal, a long, folding table at the front. Microphones they had never used before. A projector displaying special enforcement hearing across the wall. Rows of chairs packed tightly together, most already filled by residents eager to witness whatever was coming. Patricia Whitcomb sat at the center of the table, posture rigid, hands clasped neatly in front of her. Her expression carried the brittle confidence of someone preparing to flex authority she believed was absolute. She glanced up as I entered, and a momentary flicker of irritation crossed her face before she smoothed it away. Eric sat 2 seats down from her. His shoulders were drawn tight. His foot tapped an anxious rhythm beneath the table. Even from across the room, I could see the strain in his jaw, the guilt weighing on him like an anchor. A board member motioned for silence. The room quieted instantly. Patricia lifted a sheet of paper and began reading. This session is convened to address serious violations of community standards by homeowner Daniel Mercer. These violations include unauthorized structures, failure to comply with board directives, and behavior unbecoming of a resident of Cedar Ridge Estates. There were murmurs behind me. Someone whispered, "Behavior unbecoming? What does that even mean?" Another muttered, "She's overreaching again." Patricia raised her hand for quiet. "Today, we will discuss penalties and determine the appropriate corrective actions." That was the moment. The point where they expected me to argue about swings and fines and compliance. But this hearing wasn't about any of that. It wasn't about the structure in my backyard. It was about the structure behind theirs. I stepped forward to the center aisle. The room fell silent again. "I have one question before we begin," I said. My voice was steady, calm, procedural. "Does the board acknowledge that it is a legally recognized association under state law?" Patricia blinked, caught off guard. "This is irrelevant," she replied sharply. "You are here to answer." "It is entirely relevant," I said, "because without legal standing, this board cannot issue fines, enforce directives, or convene hearings. Before any discussion continues, I am requesting confirmation of standing." A wave of whispers washed across the room. The residents leaned forward. A few lifted their phones, recording. Patricia stiffened. "The board's authority is established and unquestioned." "Established where?" I asked. "In which filing? With which renewal? Under which statutory requirement?" I lifted the binder and set it on the nearest table. The sound echoed through the room like a gavel. "This," I continued, "is the county's certified record of Cedar Ridge Estates. It shows that 6 years ago, when the developer withdrew, the association was required to reestablish its corporate status under state statute. It never did." Gasps rippled through the crowd. I opened the binder, page after page of stamped official filings, missing dates, gaps where renewal documents should have been. The silence in the room deepened. "These documents demonstrate clearly," I said, "that the board has been operating without legal standing for more than half a decade. Every election since then is invalid. Every fine is void. Every lien threat is unenforceable. This hearing has no legal basis to exist." Patricia's face drained of color. She started to speak, but Eric suddenly shifted in his seat. His hands trembled as he stood. "The filings are correct," he said quietly, voice cracking under the weight of truth. "We knew about the lapse. It was never fixed." His eyes lowered. "She told us to ignore it." The room erupted. Residents stood. Voices rose, not in chaos, but in realization. Years of tension finally snapping into clarity. Patricia pounded the table for silence, but her authority evaporated in real time. "This hearing is adjourned," I said, calm, measured, certain. "All further matters will be addressed before the county judge." The residents parted as I walked toward the exit. Some murmured thanks. Others simply stepped aside, with a look of stunned relief. Behind me, the board sat shattered under the weight of a truth they could no longer outrun. And the community, for the first time in years, saw the system for what it had become. When I stepped out of the clubhouse, the crowd followed in a slow, stunned wave, as if the air inside had emptied out and rushed with them. Conversations broke open around me, questions, relief, quiet anger that had finally found a voice. The board remained trapped inside, their authority dissolved under the weight of evidence they could no longer disguise. For the first time in months, Cedar Ridge sounded alive, but the final step wasn't here. It was in the county courthouse. 2 days later, I stood in the same courtroom where Patricia had grabbed my daughter's arm, the memory still sharp in the corner of my mind. The wooden benches were filled, not just with residents, but with people from outside the neighborhood who had heard about the confrontation. News had traveled fast. The clerk called our case. The judge, methodical, composed, familiar, took his seat. The board filed in like a fractured line. Patricia's confidence was gone. Her expression held the brittle tension of someone aware the ground beneath her had already vanished. Eric walked several steps behind them, shoulders lowered, gaze fixed forward, not in shame, but in the hard acceptance of truth. The judge began by reviewing the binder I had submitted, page after page, stamp after stamp. He scanned the filings silently for several minutes, the room holding its breath. Procedure. That was the language he spoke better than anyone in the building. When he finished, he closed the binder gently, folded his hands, and looked at the board. This association, he said, has not possessed legal standing for more than 6 years. As such, every enforcement action, fine, lien threat, and internal hearing conducted during that period is void. The words didn't explode. They settled, heavy, precise, undeniable. The judge continued. Additionally, the attempt to remove a child from this courtroom during a public hearing, as well as the physical contact described in sworn statements, will be forwarded to the district attorney for review. Patricia's eyes widened, but she did not speak. The board members beside her slumped, their postures collapsing like a structure deprived of its beams. As of this moment, the judge said, the Cedar Ridge Estates Homeowners Association Board is formally dissolved. A court-appointed administrator will assume temporary control until lawful elections can be conducted. A murmur of disbelief swept across the courtroom, then relief. Deep, unrestrained relief. Residents exchanged glances of validation, as if years of pressure had finally lifted. The judge turned next to Eric. Treasurer Holloway, your cooperation has been noted. You will meet with the administrator to provide a full account of records and internal communications. Eric's nod was small but steady. For the first time, he wasn't shrinking. He was standing. The judge then addressed me directly. Mr. Mercer, the swing in your backyard predates any restrictive amendments. It is lawful. You are entitled to damages for wrongful enforcement. The amount will be determined after administrative review. I thanked him with a quiet nod. When the session concluded, people approached me, some with gratitude, others with apologies for not speaking sooner. An elderly couple said they wished they had known how to stand against the board years ago. A father with 2 small children said he could finally remove the tarp the HOA had forced him to wrap around his backyard shed. A woman whispered that she had lived afraid in her own home and was ready to breathe again. Outside the courthouse, the sky stretched wide and clear. The symbolic weight of the neighborhood's fear had broken. Authority had met the limits of law, and the law had held. As I walked to my car, my daughter ran into my arms. She had been waiting with a friend, coloring in her sketchbook. She asked if the swing was safe now. I told her it was, and not because the board said so, because the truth had finally been recognized. Back at Cedar Ridge Estates, the temporary administrator arrived within days. Notices were replaced with updates. Fines were rescinded. Access was restored. The community clubhouse opened for gatherings again, not hearings. Neighbors lingered outside in the evenings, no longer afraid to be seen using their own property. I rebuilt the swing side rail, tightening the bolts my wife had installed years ago. My daughter climbed onto the seat and pushed off gently, her laughter rising into the air. The sound carried across the yard, light and unburdened. Justice had not just corrected the system, it had restored the peace the system tried to take. Standing there beneath the late afternoon sun, I finally felt the tension that had lived in my chest for months dissolve. Cedar Ridge was ours again, not theirs, ours. If you want more stories of homeowners standing up to HOA tyranny, hit subscribe right now, share your story in the comments, and let me know where you're watching from.